Hey guys, this video is the first video in a series on divorce in Singapore. So, divorce in Singapore is governed under the Women's Charter. It's an act of parliament. Under the Women's Charter, there is only one ground of divorce, which is the irretrievable breakdown of marriage. There are several facts that the person can rely on to show that the marriage has irretrievably broken down, which I shall discuss later. Before we go into the different facts for the breakdown of marriage, in order to get divorced, you have to be married for at least 3 years. If you have not been married for at least 3 years, you cannot apply for a divorce. For foreigners, you have to be who are married overseas, you have to live in Singapore for at least 3 years before applying for a divorce in Singapore. Only in special cases, very extreme cases, a divorce can be filed before there has been 3 years of marriage. However, the plaintiff will have to prove that he or she has suffered exceptional hardship, or that the spouse have been exceptionally unreasonable and cruel. For example, beating the wife every day until she bleeds or she goes to the hospital. Or another example would be one of the spouses is having a terminal illness, is dying soon, has a few weeks left, and does not want to stay married to the spouse. Therefore, the court may, and there's quite a high hurdle, may grant a divorce if the parties have not been if the parties have not been married for more than 3 years. So, as I mentioned earlier, the sole ground for divorce in Singapore is the irretrievable breakdown of marriage. The plaintiff will have to prove at least one of these legally defined facts. Number 1, adultery. Number 2, unreasonable behavior. Number 3, desertion. Number 4, separation. I will now discuss adultery. If a spouse has committed adultery and the other person finds it intolerable to live with the adulterer, then the spouse, the innocent party, can apply for divorce based on adultery. But the main hurdle for adultery is proving adultery. How do you prove adultery since the cheating spouse is unlikely to admit to adultery? Also, the cost is quite substantial because the mistress or the toy boy, the boyfriend, whatever you call it, will have to be added as a co-defendant under the divorce proceedings. The next fact for proving irretrievable breakdown of marriage: unreasonable behavior. What is unreasonable behavior? Well, the list is inexhaustive. That means there are many different examples of unreasonable behavior, and it's not possible to list all of them out. But they include violence, that means beating, constant late nights, drinking, or constant late nights socializing with women, refusal to socialize with your spouse, drug addiction, cold wars, silent treatment between spouses, refusing to speak to each other for months at a time, frequent quarrels, compulsive gambling habits, refusal to do that thing, working too many hours. These are examples, but are not exhaustive of unreasonable behavior. The third fact that the plaintiff can rely on is desertion. Desertion is described in the Women's Charter as a spouse deserting the other spouse for a continuous period of at least 2 years immediately before the filing of divorce. This is quite a common ground for foreign brides, where the local guy marries a foreigner and she doesn't like Singapore and she just packs her bags and goes back to Vietnam, Philippines, or whatever country she came from. So, the plaintiff, that means the local, will have to show that they have been living separately and that the spouse has the intention to desert. This can usually be shown by, packing up and leave. This is usually shown that there is no intention of returning, or for a foreign spouse, packing up, leaving, buying a one-way ticket back to her country. The third fact to prove irretrievable breakdown of marriage is separation for 3 years. For 3 years separation, the other spouse has to consent to the divorce. So the plaintiff has to prove that he and the spouse have lived separately continuously for a period of 3 years. Okay, the plaintiff will have to show evidence of living separately, for example, separate homes or even separate rooms in the same home. Sometimes a deed of separation is useful to show the date which the parties have separated. For this fact of separation for 3 years, the living apart must be by choice of the parties. That means they must choose to live apart, okay, and not due to necessity. For example, like the husband was posted overseas. If the husband was posted overseas for 3 years, it is not counted under the 3 years. Finally, separation for 4 years. For 4 years separation, the consent of the spouse is not required for the divorce proceedings. All the plaintiff needs to show is that he and his spouse have continuously lived apart for 4 years. So thanks for watching this introductory video on divorce. I'll be going into detail in later